So friends, an important ruling was just handed down by a judge in California. Now, we all saw the devastation wrought when the Trump administration callously and cavalierly fired thousands of federal government employees who were relatively new hires, folks who are on what's called probationary status. Well, a federal judge just ruled that those firings were illegal. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, the Trump administration, in its first weeks in power, directed the firing of thousands of federal government employees. And you know how much advance notice those employees got that they would be let go, that they would be terminated? Well, the firing directive went out on Friday, February 14th, and it required that the firings be accomplished no later than close of business on Monday, February 17th. Yeah, one business day. Talk about the chaos, the callousness, the cruelty. Well, now a federal judge in California has determined that those firings were unlawful. They were illegal. Let's start with the new reporting. This from NPR. Headline, Judge says Trump's mass firing of federal employees is illegal and should be stopped. And that article begins, a federal judge in San Francisco says the Trump administration's firing of thousands of probationary employees is illegal and should be stopped. U.S. District Judge William Alsup says the U.S. Office of Personnel Management, OPM, must rescind directives sent to some agencies ordering them to fire their probationary employees, typically those in their first or second year in a job. Alsup issued the temporary restraining order at the end of a hearing on Thursday. His order covers agencies whose firings impact the civic organizations that sued the Trump administration. Those agencies include the Department of Veterans Affairs, the National Park Service, the Small Business Administration, the Bureau of Land Management, the Department of Defense, and the Fish and Wildlife Services. And friends, as I mentioned just a minute ago, an OPM memo to human resource officers dated February 14th says, we have asked that you separate probationary employees no later than end of the day, Monday, February 17. That's right, over the weekend. Not really even one full business day's worth of advanced notice that people who had been working for the federal government for 6 months, a year, some of them just shy of 2 years, who were still probationary employees, got about half a day's worth of notice that you are gone, terminated, shit-canned, get out. Talk about the chaos, the callousness, the cruelty. This has nothing to do with cutting fraud, waste, and abuse. This has nothing to do with efficiency in government. This has everything to do with creating as much chaos and confusion and harming thousands and thousands of public servants just gratuitously. Just what? For sport? All my editorial edition. The article continues. This from Judge Alsup. Quote, how could so much of the workforce be amputated suddenly overnight? It's so irregular and widespread, so aberrant in the history of the country, the judge said from the bench. And friends, here's something that I'm looking forward to as one of the next steps in this case. The judge scheduled another hearing in 2 weeks to hear from people in key positions. They include Charles Ezell, the acting director of OPM, as well as agency leaders who were on the receiving end of his agency's orders. Friends, I like that last part. You see what the judge did there? He said he'll be setting future hearings and will be requiring Trump administration officials to come in and be questioned about these illegal firings. Put a pin in that. We're going to circle back to that in a minute, because now the question is, okay, what happens next? Now that a federal court judge just handed down this order, well, inevitably, we're going to start to see the Trump administration trying to appeal these rulings, even if they're only temporary rulings, preliminary injunctions, and they're going to hope that they can bubble it all the way up to what Donald Trump often calls his Supreme Court. Because let's face it, the Supreme Court seems to be revealing an appetite to wade into these cases, at least when Donald Trump is on the losing end of a lower court decision, wade into these cases, at least administratively, and putting pauses in place, pausing these lower court rulings that are being entered against Trump and his administration. Because remember, that's what the Supreme Court just did in another case, when a trial court judge ordered that the Trump administration had to unfreeze billions of dollars that were supposed to go to US aid organizations. Indeed, the invoices were flowing in from these US aid organizations with whom the Trump administration had contracted. You know, in a very real sense, those bills had come due and were going unpaid. So a trial court judge said, unfreeze the damn funds. I don't think the trial court judge used the word damn. That was mine. And pay these invoices. Congress appropriated this money as part of, a U.S. aid package. So, of course, the Supreme Court swooped in and put an administrative stay in place, paused the judge's order directing that the funds be unfrozen and that the Trump administration pay its damn bills, its financial obligations. That was Chief Justice Roberts, who came galloping in to the aid of Trump and company. So yes, they are beginning to show an appetite to try to continue to do favors for Trump and his administration. But friends, now let's circle back to the issue of what happens when trial court judges begin to require Trump administration officials and agency heads to come in and answer questions about what courts are finding are illegal terminations, illegal firings of probationary employees. So friends, here's a big ticket question. A question that is likely to become relevant very soon. When federal court judges issue orders, like, for example, ordering Trump administration officials to appear in court and testify about these illegal firings, or when federal court judges issue contempt orders in the event an administration official fails to appear, fails to testify, fails to comply with earlier federal court orders, who enforces those orders? Well, to answer that question, we're going to have to go, as we often do, to the big, ugly blue book of federal laws, the United States Code, and specifically, for those of you scoring at home, it's going to be Title 28, Section 566 of the United States Code, and here's how it reads. Section 566A. It is the primary role and mission of the United States Marshals Service to provide for the security and to obey, execute, and enforce all orders of the United States district courts, and then dropping down to subsection C, the United States Marshals Service shall execute all lawful writs, process, and orders issued under the authority of the United States, meaning federal court judges, and shall command all necessary assistance to execute its duties. That's right, friends. When a federal court judge issues an order, the law provides that the U.S. Marshals Service shall execute that order. And if the marshals need help, the law provides that they shall command all necessary assistance to execute its duties. And now you might say, well, Glenn, wait a minute. Isn't the U.S. Marshals Service part of the Department of Justice, part of the executive branch under Donald Trump's control? The answer is yes. But here's the thing. The federal law provides that regardless of where the Marshals Service is housed, which organization, which entity, which branch of government, the federal law provides that the U.S. Marshals Service shall execute all federal court orders. Not, they shall execute federal court orders unless some flunky of Donald Trump in the executive branch tells them not to. You can read Section 566 forwards and backwards. You're not going to see that kind of a caveat, escape clause, exception. No, the U.S. Marshals Service shall execute federal court orders. And let me tell you, friends, having worked with the Marshals for decades as a federal prosecutor, when you hear that saying, the U.S. Marshals always get their man or woman, they do. They don't F around. They comply with federal law, with their duties, their responsibilities to execute court orders. Now, let me say this, friends. I don't often have teasers in my Daily Justice Matters videos saying tune in tomorrow, but tune in tomorrow. And the reason I'm saying that is because I recently sat down with a retired U.S. Deputy Marshal. He actually was a marshal for 25 years. He retired from the Marshals Service. He served in the upper echelons of the U.S. Marshals Service, including as an assistant director. And his name is Arthur Roderick, Art Roderick. And we talked about the interplay between the U.S. Marshals Service, the federal courts, and the Department of Justice. And I'm going to ask you to tune in tomorrow because we're going to sort of put some meat on the bones of this discussion regarding what happens if, responsibilities collide. If the law tells the marshals, oh, no, you execute this federal judge's order to, go out and get a Trump administration official and bring him to court so he can testify because he has been ordered to testify. But you have somebody in Donald Trump's executive branch or Department of Justice saying, no, we're not going to let the marshals comply with their sworn legal duties. What happens? Tune in tomorrow, where I have a sit down with, as I say, retired U.S. Deputy Marshal Art Roderick, and we talk about these issues that are very likely to bubble up in the near future. But I'll leave you with this, friends. In my experience, U.S. Marshals take their legal obligations deadly seriously because they know, as we know, that justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.